अरे भाई पानी भर ले यार।
Welcome back, guys. Oh, it's 3:45 now. 5 minutes of extra time. Okay. So we were discussing about the revisory jurisdiction. That was the last topic. Now, moving on to the next type of jurisdiction. Before this, let's solve a question. I'll give you 30 seconds. Mark the answer. %39 marked A, 33% marked C. The question says, any retired judge of the Supreme Court of India can be called back to sit by the Chief Justice of India with prior permission of the President of India. Of course, retired Supreme Court judge, retired judges, Article 128. One is correct. This is Article 128. Okay, one is correct. These two can't be the answers. Now, a High Court in India has the power to review its own judgment as the Supreme Court does. You know, this is actually a correct statement because High Courts are also court of records. In 1963, Supreme Court has clarified that High Courts also have the power to review their own decisions. Secondly, even in 2020, there was a judgment on the same lines in the Kerala High Court. However, when the UPSC answer key came, the right answer was A, one only, which in my opinion is a wrong answer. Had they mentioned a statement called with reference to Indian Constitution, then this could have been seen as correct because nowhere is it mentioned in the Constitution that High Courts can review their own decisions. It is mentioned for Supreme Court, Article 137. But for High Courts, it is not mentioned in the Constitution. But with reference to Indian judiciary, this statement should have been correct. This is ideally correct. So I'll mention here UPSC answer key says A, but the correct answer is actually C. Now you may say, sir, what is this nonsense? Then how will we know? Some mistakes are going to happen. This is bound to happen, right? Errors in answer keys will always be there. And since UPSC releases the answer keys after the examination, of course, it goes on to say that you can never, while the examination is going on, as in prelims, mains, etc., you cannot question the answer key because you know the answer key. And once the exam process is over, then there's no point in questioning the answer key. That is what is actually a cause of concern. But UPSC always releases the answer key after the end of examination. You cannot actually challenge it. But here, the right answer should have been C. That is the High Court in India also has a power to review its own judgment as the Supreme Court does. Why? Because High Courts are also what? Courts of record. This is a reason. Anyway, moving on, ignoring these small mistakes. Next is advisory jurisdiction. So what is this advisory jurisdiction? So this is Article 143. And you know, sometimes the government may want to seek some advice from Supreme Court on various matters. So the president seeks advice or opinion from Supreme Court. Now, president seeks opinion from Supreme Court on what kind of matters? Sometimes legal opinion on general matters. Legal opinion on general matters. Sometimes also seeking opinion on interpretation of laws. So, when you seek opinion on a legal matter or legal opinion on general matter, here Supreme Court may or may not give opinion. if you are randomly asking Supreme Court judges for an opinion, they may refuse also. But if the government wants to clarify some provision of the constitution, if the government wants some clarity on the meaning of some words, that is, they are asking the Supreme Court to interpret some laws, then here Supreme Court must give opinion. However, whatever opinion you give, it is not binding on the government. Okay, that's also there. Now, this advisory jurisdiction is normally referred to as presidential reference. And sometimes you will also see this RE mentioned before some case. RE, Berubari Union. Whenever you find this kind of phrase, that is not a court case exactly, that is the government seeking Supreme Court's opinion, right? A very good example of this is the third judge's case. It was not actually a case, it was the president seeking clarification on the collegium concept, which was there in 1993. Let's look at this. See this phrase mentioned here. Presidential reference under Article 143, right? So this was just a clarification being sought. Opinion of Supreme Court on interpretation of Article 124, right? So that is it. This is called advisory jurisdiction, and let me remind you, advisory jurisdiction has to be done by minimum 5 judges. Minimum 5 judge bench. It's mandatory. So that is there. Advisory jurisdiction. So this is with respect to Article 143. And let me clarify, Supreme Court is not Amir Khan. They need not give free advice. They'll only give advice when asked. Don't act over smart. Give advice when the government is asking. That's the whole concept. Okay, this is Article 143. Solve a question quickly. Poll, 30 seconds, not more than that. Easy question. Please solve quickly. Yes, Vipin, third judge's case is an example. Shiva, why can you not challenge UPSC? Because that's how the exam pattern is set. They have very clearly said the result will only be out after. Oh, my bad. I think I mistakenly marked A as the correct answer. The correct answer is B. My bad. Consider the following statements. The Supreme Court of India tenders advice to the President of India on matters of law or fact on its own initiative. Of course, not when nobody is asking you. Please don't give advice. Only if the matters relate to fundamental rights, not correct. If he seeks such an advice. 2. B2 only is the correct answer. Apologies for all those who got this incorrect. The right answer is actually B and not A. Okay. Now, writ jurisdiction. So, what is the meaning of writ firstly? Writ basically means order or directive. That is called writ. The meaning of this word writ is order, giving orders. This is Article 32 of the Indian Constitution. Now, one more point. This writ jurisdiction is also there with high courts. What is this writ jurisdiction? This is used by Supreme Court only in one case: to protect what? Fundamental rights. That's it. Only in one case. And Parliament has the power to enlarge this writ jurisdiction of the Supreme Court. Parliament by law can increase the writ jurisdiction of the Supreme Court. So this writ jurisdiction is actually direct, meaning if your fundamental rights are violated, you can directly go to Supreme Court. But can you go only to Supreme Court? No, no, no. You can also go to high courts. That is why direct, but not exclusive. Why? Because it is shared between the high courts and the Supreme Court. This is called writ jurisdiction of the Supreme Court. There are various kinds of writs: habeas corpus, mandamus, prohibition, certiorari, quo warranto. So all these writs we'll study when we study fundamental rights. Then some other important provisions like Article 138. Supreme Court's jurisdiction can be enlarged by the Parliament. Very important, right? In fact, Parliament by law. Let me ask you a simple question. To increase or enlarge the power of Supreme Court, right? Parliament can do it by a simple majority. What is the step required to decrease the power of Supreme Court? Please write. I hope we are all awake post lunch. Important, right? Coffee, tea, whatever keeps you awake. Please write the answer. To decrease the power of Supreme Court, what kind of majority is required? Cannot do. Can't. Oh. It can be done. We would require a special majority with also the consent of half of the states. That is there. So special majority. It's a very beautiful situation. To decrease the power of Supreme Courts, you need a special majority. But to increase the power, you require a simple majority. Very easy to increase power, very difficult to decrease power. That's it. Then Supreme Court also has the power to transfer cases from one high court to another. Okay. This was added via 42nd Amendment Act 1976. So Supreme Court can transfer cases from one high court to another or from one high court to itself. This can be done suo motu. What is suo motu? Suo motu, suo motu, same thing. It means on its own motion, on its own, by itself. So Supreme Court can transfer cases from one high court to another on its own, completely on its own. Number two, when petitioner requests. For example, if you remember this case of Nupur Sharma, right? So when Nupur Sharma made a statement, lot of cases of blasphemy, IPC section 505, 295A, random kind of cases were filed against her in various courts across the country. So she went to the Supreme Court asking Supreme Court to issue orders to transfer all these cases filed in various courts to Delhi only, because it made no sense. The same matter was there, multiple cases filed in multiple courts. So she was requesting Supreme Court to transfer all the cases to one court only. That's it. Or sometimes this can also be done if the Attorney General requests. Now let us say Attorney General has to deal with matter which relates to government's performance of functions. Or suddenly one more case comes up at the same time in some other high court. Now, it will be difficult for him to travel to multiple places. So he can simply ask the Supreme Court, sir, my lords, we call them my lords. So, my lords, my lords. So, my lord, please transfer the case from that high court to Supreme Court. If I have to travel, I'll only be wasting government's money. If you transfer the case here, it will be amazing. So, that can also be done. Okay. And lastly, Article 141. The law declared by the Supreme Court is binding on all the courts in the territory of India. So, one Supreme Court says this is the meaning of the law, it is final. It is binding on every court in the territory of India. That's the beauty of the Supreme Court's power. Binding. Okay, that's there. Then, we have seen, and we'll be discussing this in detail, this thing called judicial activism, where Supreme Court interferes here, there, everywhere. Where do you think is judiciary getting this power from? This concept of activism, where they are telling people what to do, what not to do, their own idea of justice, sometimes appropriate, sometimes without any understanding of the Indian cultural environment. So Supreme Court can even tell the legislature, the executive, on the performance of functions, etc. How? Because of Article 142. This is a source of judicial activism. It provides absolute power to Supreme Court. The Supreme Court, in the exercise of its jurisdiction, may pass such decree. Decree means conclusion. This word decree, it actually means conclusion. May pass such decree or make such orders. Can give any order, any conclusion, as is necessary for doing complete justice. Mind you this phrase. Supreme Court wants to do complete justice, and in pursuance of complete justice, it can pass any kind of order on any matter, any cause pending before it. And any decree so passed or order so made shall be enforceable throughout the territory of India. So this is what is a source of activism, because if a matter comes to me, whether it is the power of legislature, whether it is power of executive, I don't care. I have to ensure complete justice, and for that I will pass any kind of judgment on that particular matter. Whether it interferes in legislative domain or executive or any other, I don't care. This is what is the absolute power of Supreme Court. Very important article, Article 142. Then Article 145, very simple, rules of Supreme Court. So, who makes the rules of functioning of Supreme Court? What will be the court fees? Which case to decide first? What kind of bench to allocate cases to? Who will do all this? Supreme Court itself. Supreme Court itself runs the whole court. No external interference. But if you remember, the same provision is there for Parliament also, right? But Supreme Court says we will interfere there. If there is anything unconstitutional happening, will interfere in Parliament's functioning. But can you interfere in Supreme Court's functioning if something wrong happens? No. You have to be a mute spectator. If you feel there's something wrong, remove the judge by provisions of Article 124. But beyond that, nothing can be done. So that's there. With the approval of President, Supreme Court can make rules for regulating generally the practice and procedure of the court. Now, As we had discussed earlier, that when it comes to bench size, in the Supreme Court, there are three kinds of benches. One is a division bench, 2 judges. One is a priority matter bench, 3 judges. And one is a constitutional bench, meaning 5 or more judges. It can be 5 judges, it can be 7, 9, 11, 13. We have so far seen 13-judge bench also. Okay. So, minimum number of judges to decide on matters of interpretation of the constitution. What is this? Constitutional bench will be how much? Shall be 5. Or matters under Article 143. What is this? Advisory jurisdiction. So there also you have to have minimum 5 judges, right? Not less than that. And every decision of the Supreme Court is given by majority judgment. What is majority judgment? 3:2, 2:1, etc. This is called majority judgment. And let's say in that particular judgment, somebody wants to give a dissenting opinion. They have every right to give a dissenting opinion. Of course, they have. But the whole point is that when you are giving a dissenting opinion, it will be recorded also, but will not be a part of, but will not affect the judgment because the judgment is given by a majority. Now, one very simple example. Let us say there is a division bench. What is division bench? How many judges? 2 judges. 2 judges. Now, in this situation, if the judges, one judge says something, the other judge says exactly opposite. The hijab case, hijab ban. In Supreme Court, if the judgment, if the verdict is 1:1, meaning one judge said hijab ban should be allowed, second judge said no hijab ban can be allowed. So, split verdict happened. This is called a split verdict. In this case, what happens? We don't do a toss and all. We simply give this particular case to a larger bench. Here, case will be transferred to a 3-judge bench. This is what is done in case a division bench gives a split verdict. So that's there. Okay. This is, and that is all as far as Supreme Court is concerned. We are done with the Supreme Court. Okay. Now coming to high courts. Very simple. How many high courts do we have in the country? We have 25 high courts in the country. 25. So 25 high courts. One more thing. When you talk about judges of the high courts, the number of judges varies from one high court to another, right? So please don't think that we have equal number of judges in all the high courts. That's not the case. The number of judges varies from one high court to another. That's a very important element that you should understand, that the number of judges in high courts is not fixed. It keeps on varying from one high court to another. So total strength. So the current total strength as on 1st of March is 1,114 judges. 6 seats have been increased recently only. So that is the total number of judges in the high courts. And this number varies from one state to another. Meaning what? Meaning if you have say 160 judges in the Allahabad High Court. 160 judges in the Allahabad High Court. That's the highest. So in the Allahabad High Court, you have 160 judges. And in Sikkim High Court, 3 judges. Tripura High Court, 5 judges. Meghalaya High Court, 4 judges. Bombay High Court, 94 judges. Madras High Court, 75 judges. Punjab Haryana High Court, 85 judges. It varies. Number is not fixed. Okay. And judges are of two kinds. One category is called permanent judges, right? And the other category is called additional. So we have some additional judges also. Okay, so this is with respect to the judges of the high courts. Now, there is a high court for each state. Yes or no? High court for each state is there. But it may not always be possible that within your state you will have a high court. That may be difficult. But every state has one high court, just like governor. And we can also have common high court for 2 or more states. That's also possible. So we can have this look here. Tell me, how many states share a high court? How many states share a high court? Please write the number quickly. How many states share the high courts? Please. Again, I am reiterating the word. How many states share a common high court? States, not UTs. States, not UTs. It is only one number. How many states? See, one is Bombay High Court. Yes or no? Goa, Maharashtra. 2 states share one high court. Then we have Guwahati High Court. Arunachal, Assam, Mizoram, Nagaland. 4 states share one more high court. Then we have Punjab and Haryana. Where? Haryana, and here we have Punjab. Let me move on one side. Punjab. That's it. So these are the states which share common high courts. All other high courts are shared by a state and a UT, like say Calcutta, Andaman Nicobar, West Bengal, JNK and Ladakh. This is a very unique high court which is shared by 2 UTs. The only such high court that is shared by 2 UTs. And it is only the second high court meant for UTs. Delhi is the first high court which was only meant for the Union Territory of Delhi. Then Kerala, Lakshadweep and Kerala, Tamil Nadu and Pondicherry, right? So this is the current situation in our country pertaining to high courts. Okay. Solve a question quickly. Came in the year 2006. Okay, 60% I marked the answer correctly. Let's see. What is the assertion? In India, every state has a high court in its territory, within its boundary. Is it correct? Of course not. Every state does not have a high court inside its territory. So assertion is wrong. both A and R are true. No, A is not true. Both A and R are, but A is not true. A is not true. So D has to be true. As Sherlock Holmes says, if every option is eliminated, whatever remains, however improbable, has to be true. So, what's the reason? The Constitution provides for a high court in each state. So, that's a correct statement. You can always say, sir, in is not a good word. We could have had a for each state, a better word. That's there. But assertion A is wrong. In India, every state has a high court in its territory is a wrong statement. We have removed A. What remains is the right answer. Now, coming to appointment, we have seen the appointment, right? Appointment is mentioned under Article 217. What is the system? Please tell me. The appointment system is the collegium system, wherein CJI plus two senior most Supreme Court judges, they will appoint. That's there, a three-judge collegium. One more thing, please write the answer for this question I'm going to ask you. To increase the number of judges in the high courts, what is required? How to increase number of judges in the high courts? Tell me quickly. Don't waste time, please. Special majority, great. Some other kind of answer? Simple majority, parliament simple majority, amendment, parliament by law. Great, great, amazing, amazing. Based on by an act, based on population, vacancy. So this is a situation, right? Let me see how many of you have mentioned the correct answer. Neil, very good. Lekha, Channabaswa, Sahyadri, Yamini. Okay. So, in the previous class, towards the last half an hour, when I had discussed, yes, Cherub Janvi, correct. I had discussed how to increase Supreme Court judges. I had mentioned the Supreme Court judges can be increased by parliament by law. But on the same page, I had also mentioned, however, the High Court judges are increased by the president, executive order of the president, not the parliament by law or amending the constitution or whatever you have written. No. To increase the number of judges in the high courts, president will issue an order and the number of judges are increased. So much so for revisions. So let me write here. Now I think I have to write this point. Article 216, number of judges can be increased by president. That is an executive order. Okay. So this is there with respect to the increase in number of judges. Right? Now, coming to the very important element, the Supreme Court judges have a retirement age of 65. The High Court judges have a retirement age of 62. Where is this mentioned? It is mentioned here, age of 62 years. So, point of difference here also. Okay. Now, one more thing. There is a concept of additional judges in the high courts. That's there. Additional judges, they are appointed for a period of 2 years. Appointed for maximum 2 years. Okay. Now, all this is clear. One more thing that you would be surprised to know is this point, that when it comes to the collegium, have you ever heard of something called High Court Collegium? There is also something called High Court Collegium, though it is just a matter of procedure. But what is High Court Collegium? This is a concept that Supreme Court has devised to help itself. Now see, if you look at the number of High Court judges, currently the vacancy is over 300, 333 is the vacancy. And you have to look into all the files of district court judges and all. It's a huge task for the three judge collegium. So what they do is they ask the High Court judges only 6 months prior to the vacancy happening, because see, vacancy date is known. You know when a judge is going to retire, because the moment he turns 62, he or she retires. So the date of retirement is a very, very well known fact. So when the date of retirement is a known fact, you know very well that in the next 6 months, these two judges are going to retire. So in my High Court, I will have two vacancies. So what's the step, the procedure? Number one, Chief Justice of the High Court plus two High Court judges, the senior most, they will recommend some names. Recommend names. Now, these names are sent to the CM and the governor for opinion. And this opinion is not binding. After the High Court has found 5, 6 or 10 names for one seat, they will send all these names to the Supreme Court Collegium, which takes the official decision of picking up the right candidate. Then step 2, names sent to Supreme Court Collegium for what? Final recommendation. So that's there. This is how the High Court Collegium works. In every High Court, you have a three judge group, the senior most three people, and they send names, 10, 20 names for every post. Of that 10, 20 names, the Supreme Court Collegium picks up one name, two names, whatever, and they send those recommendations to the president. Okay, this is how things work in reality. So don't worry, this is not a part of some judgment. This is just a matter of procedure, because Supreme Court wants to perform its tasks with ease. Hence, they have found this kind of alternative with respect to the functioning of the collegium in the Supreme Court. Okay, that's there. No, Sahyadri, there is no minimum age of appointment anywhere for High Court or Supreme Court. Though, if you ask me, there is a convention, a tradition, a custom that normally high court judges are not appointed below the age of 45. Normally, they are at least of the age of 45. Normally. But this is just a convention or a custom or a practice. We have seen on so many occasions, a lot of high court judges have been under 45 also. The current Chief Justice of India, D.Y. Chandrachud, was actually, I think, of the age 39, if I'm not wrong, when he became the High Court judge. So, youngest, one of the youngest to become High Court judges. Yes, Sushri, of course, Supreme Court sends to President, then President decides. That's all. Of course, we have discussed the collegium process. That's there. I'm just discussing what happens before that. So, this is a appointment of the High Court judges. Now, qualification. Just two qualifications. Don't forget, of course, you have to be what? A citizen of India. That goes without saying. Citizen. Beyond that, what's the qualification? You have to hold some judicial office. Judicial officer for 10 years. What is judicial officer? Judge in the lower court. That is a judicial officer. Or you have to be an advocate in the High Court for 10 years. So that's there with respect to the qualification. Here, there is no such qualification with respect to eminent jurist. That's only meant for Supreme Court. One more thing. How are these people removed? Please tell me. Removal. Same as Supreme Court judge. We have seen this today only. Removal is similar to a Supreme Court judge. Then, one more point. A very important observation. Salary of High Court judge charged on what? CFS. What is CFS? Consolidated Fund of the State. Salary is charged on CFS. Pension CFI. Or let me write charged. Charged on CFI. A very, very important point. Please don't forget this point. There can always be a question on this. The pension of High Court judges is charged on not CFS, CFI, but salary is charged on CFS. That's there. Because a High Court judge, normally gets transferred and can act as a High Court judge in multiple places. So why to burden any single state with respect to pension? Center pays the pension. One more important element, a very, very important element. Please understand this point also. So we have something called Article 124, Clause 7. Do you remember? That once you have become a Supreme Court judge, you can never practice in any court of law in the territory of India. A similar provision is there for High Court also, but slightly different. Here, on retirement, cannot plead or act in those high courts where he or she has been a judge. Are you clear on this? So, For High Court judges, there is a very interesting option. High Court judges can become lawyers in Supreme Court. It's very common. A lot of High Court judges become advocates in Supreme Court. I am actually, one more side note, I am using interchangeably lawyer and advocate, but the right term is advocate, because lawyer is somebody who has a degree in law. But after having a degree in law, you also need to clear an examination, the bar council examination under the Advocates Act. And once you clear the bar council examination, then you become an advocate. So advocates are allowed to fight cases in the court, right? So prefer using the term advocate only. It's a more legally appropriate term. Anyway, so as I was saying, lot of high court judges actually act as advocates in Supreme Court. Why? Because on retirement, once you retire, you will not be allowed to plead or act as an advocate in only those high courts where you have served as a judge. And you have not served as a judge in Supreme Court, so you can act in Supreme Court. For example, if there was a judge who was acting as a judge in the Jodhpur High Court, then he got transferred to, say, Bombay High Court, then he got transferred to MP High Court, and finally he became the Chief Justice of Madras High Court, and he retired. Now, can he act as a lawyer or advocate in Madhya Pradesh High Court? Of course not. Can he act as a lawyer in Patna High Court? Of course, yes. Can he act as a lawyer in Supreme Court? Of course, yes. Can he act as a lawyer in Bombay High Court? Of course not, because he has been a judge there. So this is for High Court judges post retirement. I hope this point is clear. Okay. Then jurisdiction. Nothing much to discuss here. First is original. So what is this original? We know direct and exclusive. So any electoral dispute pertaining to the elections of parliament and state legislatures is to be taken care of by the high courts. Meaning what? We are referring to election disputes involving MP, involving MLA, involving MLC. Okay. So this is there with respect to original jurisdiction. Now, second thing is admiralty, involving law of seas. If any issue happens in the territorial waters of India, then the deciding authority is the corresponding high court. For example, say this is a particular, this is a peninsular India. Something happens here. So this issue will be decided by the corresponding high court. So this is called admiralty involving law of seas. These are two situations of original jurisdiction. Then when it comes to appellate, see, as far as appellate is concerned, everything that is being done in the high courts is appeal only. High courts are meant to be called court of appeal because every lower court judgment can go to high court. No need of permission, certificate, whatever, not required. Every person can approach the high court by way of appeal against a lower court judgment. So all the civil, all the criminal matters come under this only. That is the purpose of high court. High courts were meant to be an insulating layer between the Supreme Court and the lower courts, right? That's it. And finally, we also have something called writ jurisdiction, that is Article 226. This is just like the Supreme Court, but with minor differences. High courts can also issue writs. What is writ? Writ means order or directive. So writ jurisdiction of the Supreme Court, of the High Court, is Article 226. What does this mean? High courts can issue orders to protect fundamental rights, just like Supreme Court, but High courts can also issue writs to protect other matters, other kind of rights, or rather, let's write for other matters. For other matters. This is the writ jurisdiction of the what? High Court. That's it. We are done with the High Courts. Solve this question. Came in the year 2007. Oh, poll. 30 seconds. Please mark the answer correctly. Great. 75% have marked the correct answer. The mode of removal of a judge of High Court in India is same. So it is same. We all know it. No problem. One is correct. These two can't be the answers. After retirement from the office, a permanent judge of a High Court cannot plead or act in any court or before any authority. Of course, he can plead or act. In Supreme Court, allowed. In all other high courts where he or she has not been a judge, it's allowed. So 2 is wrong. Hence A, 1 only is the right answer. Okay. Now we'll discuss the subordinate courts and the structure of the subordinate courts. So what exactly is the structure of our lower courts? Again, as far as lower courts are concerned, I'll draw the structure. It varies slightly from one state to another. As far as our now, very important element. In our country, this number varies a lot. We have around 20, current data says, we have around 25,000 plus judges in the lower courts across the country. So exact figure, though it is of no use to you, is 25,129 judges. But in your examination, you can simply write over 25,000 judges. Okay, that's it. Now, there are at the subordinate court level, in every district, we have the topmost court in the district. That's the highest court. That court is called the District and Sessions Court. This is the highest court in any district. Okay. And the judge here is called District and Sessions Judge. That is what is the name of the judge. Now there are two sides, the civil side and the session side. Civil side refers to civil cases. Session side or the magisterial side refers to criminal cases. This refers to criminal matters. Okay, that's it. Do you want a break, guys? Is Because we have just had a very small duration. Let me take a poll. Don't worry, poll. 10 seconds. A for yes, B for no. Or you can finish subordinate quotes and then take a break. Oh, it's very close. Okay, 7 minutes of break. Be back at 4:50. That would be sufficient, I believe. And then we'll continue. Full respect for democracy. Yes, yes. We are in a democracy, respecting democracy. Please be back by 4:50 because we will already have a session, a break at 5:40. Okay? Break, please. Be back quickly. Let's continue, guys. Okay, so is this condition also applicable to additional judge also? Yes, yes, of course. PIL. Rani, PIL will depend on basically the type of matter under the litigation, but in general, PILs largely refer to some kind of rights being protected. That is why PILs are largely under writ jurisdiction, and that's also a reason why PILs are not filed in the lower court but only High Court or Supreme Court. Qualification for acting in addition, Mandeep, it's the same qualification. If you have to be an acting or additional judge in the High Court, you have to have the same qualification to be a High Court judge. The qualification is exactly the same. The appointment done by the president. The only condition is to be an additional judge. The maximum period for which you can be an additional judge is 2 years. That's it. Civil cases are cases which pertain to civil matters like providing compensation, etc. Shiva can act in subordinate court. Why will a retired high court judge go and be a lawyer in subordinate court? Of course, he cannot in that area, but won't happen. See, additional judge is basically a very unique way in which, if at any point of time, it's more like a temporary judge only. Additional judge is like an ad hoc judge for high court. Think of it like this only. Okay, ad hoc judge for high court, a very unique way where we can, if the cases are too many, we can appoint some ad hoc judges, additional judges, for a temporary period of maximum 2 years. That is the concept of additional judges in the high courts. Okay, great. Now coming to subordinate courts, back again. So as I said, we have two sides in the lower judiciary: the civil side and the criminal side. Civil side is the civil judges and all. Criminal side, you have the sessions judge. So at the civil side, you will call these people as civil judges, sometimes called district judges. It's the same name. No worries, no difference on that. Civil judge, additional civil judge, at the session side, you have sessions judge and additional sessions judge. Okay. Now, all these people, right from district and sessions court to civil judges, sessions judges, all these people are referred to by a common name. They are all collectively a part of higher judicial service. So they are a part of higher judicial services. Below that, we have the second category, the lower judicial services. At the civil side, you will have subordinate judge, senior division. In some states, they give them rank, like sub judge 1, sub judge 2. In some states, they call them senior division, junior division. Then at the lowest level, you may also have munsif. That's also there. At the criminal side, you have chief judicial magistrate. Chief judicial magistrate. Below them, you have additional judicial magistrate. Judicial magistrate. Below them, you have a judicial magistrate first class, JM first class. These are the people who are authorized to issue arrest warrant. Okay. So in case you are an IPS officer in future, the arrest warrant to issue all your enemies has to be issued by judicial magistrate only. These people are collectively called lower judicial services. Okay. Now, there is one more very unique categorization. Below this, all these people that you can see here, everybody right from here till here, everybody, they are all called by a common name: district judge. Everybody here is called a district judge only, like a general name. Like all people in the parliament are called MPs. Then you have MP in Lok Sabha, MP in Raj Sabha. Then some MP can be minister, some MP can be leader of opposition. So names can vary, categories can vary, but in general, all these people are called district judges. So when I say he or she is a district judge, I have to clarify sessions judge or a civil judge, and then clarify rank also. Right? So district judge is a common name for all such judges. Number one. Number two, before you can enter the level of district judge, there is also one post that is the lowest in the judicial hierarchy, the lowest judicial officer, that is called magistrate cum civil judge. That's the last in the hierarchy. Magistrate cum civil judge. This is covered under Article 234, and district judges come under Article 233. I hope this point is clear. Now I'll explain further. Magistrate cum civil judge, who is this person after all? So in all your states, you'd have this examination conducted by SPSC. The State Public Service Commission conducts the judicial examination. When you clear that examination, where are you hired? You are hired at this level. Here, this level, magistrate cum civil judge. Article 234. This is where you are hired if you clear the judicial service examination. So basically, SPSC conducts the exam and interview is conducted by the high courts, and even the paper is set by high court only, right? So the lowest level of judge, who is not a district judge, that person is selected through an examination. Okay, so these people you see here are appointed through what? Examination. Okay, and then how are district judges appointed? There are two ways. Either you get promoted. If you're a subordinate judge, get promoted, go here, come here. That can be done. Okay, so either you get promoted, or if you have been a lawyer for 7 years. So any person who is an advocate for 7 years, advocate or pleader is the same thing, for 7 years can become a district judge or officer in the judicial service of the union. This is basically via promotion. And let me also clarify one more thing. A chief judicial magistrate can come here also, can go here also, can go here also. It can move anywhere. It is not that once you are a sessions judge, you'll always be a sessions judge only. It can change. For example, and this is how it happens also. If I, the same person, am teaching this class, same students, and I'm teaching polity, this becomes a polity class. But if tomorrow magically I get some knowledge of, say, economics also, and I start teaching economics, same students, same teacher becomes an economics class. So if a judicial magistrate is taking up a criminal case, or if a district judge will take up a criminal case, he will be called a sessions judge. If a district judge takes up a civil case, he is called a civil judge. So you can have intertransferability and interchangeability of roles. I hope this point is clear. It is just that if you are taking up a certain matter, you are referred to with that particular title. That's it. Okay. One more thing. When it comes to now, so as far as Supreme Court and High Courts are concerned, there is no minimum age. There is no minimum age. But for subordinate courts, there is a minimum age. I mean, because you are, of course, entering the lowest layer of judiciary, magistrate cum civil judge, you can say that 21 is the minimum age, because most states have their exams where they allow people from the age of 21 to appear for the examination. In that sense, yes. Otherwise, for the judiciary in our country, district judges, the high courts and Supreme Courts, there is no minimum age of retirement. And for district judges, the age of retirement is 60 years. That is standard across the country. One more thing. Yes, Lakshmi, some states have 23, some states have 21. This number varies. It's not fixed. Even the nomenclature varies. In some states, you will have a magistrate second class also, third class also. Some states don't have munsif, other states have munsif. So these nomenclatures vary. One more important provision. The district and sessions judge, they are also allowed to provide for death sentences. That's there. So the sessions side, they can award death sentences also. Mind you, if a lower court gives you death sentence, that punishment cannot be executed without the approval of High Court. To execute, High Court's permission required. So maybe, let us say, the lower court gives you a death sentence. You may appeal against it. You may say, no, I accept it. I am going to die. But even for that, High Court has to approve that, okay, death sentence approved. Without High Court's approval, lower court's death sentence punishment cannot be executed. Right? That's there. That's it as far as the lower courts are concerned. We are done with our subordinate courts as well. Okay. So that was the court structure in a country, the three-tier structure: the Supreme Court, the High Courts, and the subordinate courts in the country. Now, just a small point to discuss: National Legal Services Authority. So, you know very well, I mean, you would not know, there is something called DPSP, Directive Principles of State Policy. As I had mentioned in one passing reference earlier also, we'll discuss this later on. But DPSP basically refers to those kind of principles, those kind of ideas that every state government or central government should incorporate while making policies and programs. So, in 1976, one new DPSP was added. That DPSP was Article 39 capital A. Article 39A. This DPSP refers to free legal aid to the poor people. Free legal aid to poor. See, the idea is that justice should not be denied to anyone because of lack of economic resources or knowledge, anything. So, the state and the center, they have a duty to ensure that justice is delivered free and competent legal services delivered to the weaker sections across the country. The whole point is equality in matter of justice also. So, in pursuance of that, the Parliament passed a law called Legal Services Authorities Act in 1987. Under this law, a body was formed. That body was called NALSA, National Legal Services Authority. Okay, access to justice for all people. That is what is NALSA, access to justice for all. And this NALSA is under the patronship of Chief Justice of India. Who is a patron in chief of NALSA? Patron in chief, CJI. But since CJI already has lot of work, so the executive chairperson, the one who actually takes care of NALSA, is the senior most Supreme Court judge. Executive chairperson is the senior most Supreme Court judge, that is after CJI, whoever is the senior most, right? That is it. So basically, CJI is holding the honorary ceremonial position of the head, the boss, the patron of NALSA, but the day-to-day functioning is controlled by CJI. Now, NALSA as a body came into force on 9th of November 1995. And what's the purpose of NALSA? The purpose is very clear: to establish a nationwide uniform network for providing free, very important, free and competent, meaning quality legal service. So legal service has to be of impeccable quality to weaker sections of the society on the basis of equal opportunity. So this is the NALSA. Now, NALSA has a proper structure. At the top, NALSA, for every state at the district level, you have SALSA, State Legal Service Authorities, SLSA, SLSA. This is SALSA. Under every state legal service authority, you have DALSA, DLSA. Under every DALSA, you don't have TALSA, it's TLSC. Taluk Legal Service Committee. By the way, we also have roughly we have 37 salsas. 37. Dalsas, the number is roughly 673, though we have 676 districts, but we have 673 Dalsas. And for Talsas, this number is over 2200. The exact number is not really important for you. I'm mentioning it here. Don't mug up the exact number. It's not possible to remember it. Apart from this, we have one Supreme Court Legal Service Committee also, plus Supreme Court Legal Service Committee. I'll explain what is their function shortly. Plus, we have High Court Legal Service Committees also, just one for Supreme Court, and I think we have 39, because 3 for Karnataka High Court, Bombay High Court, etc. Okay, 39. So we have 39 High Court Legal Service Committees. But what's the point of all this structure? What is the task of NALSA, DALSA, SALSA, etc.? Number one, please focus. Legal aid and assistance. So NALSA, SALSA, Supreme Court Authority, High Court Authority, they provide legal assistance free of cost, right, to people who are in need and eligible persons, not to any random person, but to eligible persons. Secondary, outreach programs, meaning spreading awareness, making people aware about their rights, entitlements. Basically, the outreach programs refer to the NALSA, SALSA conducting what? Conducting these campaigns wherein they tell people on how to approach the courts, what kind of rights do people have, etc. Then Lok Adalat. Now, what is Lok Adalat? Please hold your horses. We'll discuss hopefully tomorrow what is Lok Adalat. And victim compensation scheme also. If there has been any case of, say, acid attack, right, maybe some issue of discrimination faced by transgenders, etc., then NALSA, SALSA, etc., they also make recommendations and try to strive to get some kind of compensation for the victim. Those four key areas. So, what they do exactly? Number one, as I said, legal awareness. They spread legal awareness. In terms of legal awareness, the best thing to tell you is that in 2021, they conducted 11.34 lakh programs. On legal awareness. Roughly 58 to 59 lakh people attended these programs, becoming more aware about their legal rights that they have. Then they conduct Lok Adalats. What is Lok Adalat? We'll discuss tomorrow. Promoting ADR. ADR means Alternative Dispute Resolution Mechanism. Again, we'll discuss tomorrow. Lok Adalat is type of ADR only. Preventive and strategic intervention programs. So basically, NALSA runs a lot of schemes. Outreach programs. All this refers to schemes run by NALSA. So you'll be surprised that NALSA runs number of schemes. For example, there is a scheme called NALSA Legal Service to Disaster Victims through LSA, scheme of 2010. There is a NALSA scheme called NALSA Victim of Trafficking and Commercial Sexual Exploitation Scheme 2015. Then there's a scheme called NALSA, Legal Service to Workers in Unorganized Sector Scheme. That's there. Then there's a scheme called NALSA, Child Friendly Legal Service to Children and Their Protection Scheme. So whether it is victims of sexual harassment, victims of child labor, mentally ill people, mentally disabled people, lot of schemes are being run. Victims of drug abuse, right? Those people, victims of acid attack. There's a very popular scheme called NALSA, Legal Service to Acid Attack Victims 2016, which provides or not provides, but which fights a case on your behalf in the court, providing for compensation for victims of acid attack, right? So these kind of schemes are run by NALSA. Then social justice litigation. What is the meaning of social justice litigation? So NALSA also fights cases in the court. To give you a very simple example, in 2014, NALSA actually won a case in the court by fighting a case to uphold the rights of transgenders. So the tasks it performs. NALSA 2014. Transgender rights, or NALSA versus Union of India. So in Vrindavan, all the widows who are living, so their lives also have to be improved, and the government should spend money for improving their lives. So this was a very popular case in 2012, captured a lot of media attention also, that NALSA won a case where Supreme Court ordered the government to provide for basic necessities of life to the widows in Vrindavan. And then, of course, providing free legal aid, advice, and counseling. NALSA provides free legal aid to people. In 2021, over 60 lakh people benefited from NALSA's free legal aid. NALSA, SALSA, DALSA, TLSC, all these things, because we have a wide network of these things. As I said, we have 37 SALSAs, 673 DALSAs, 2,281 TLSCs, 1 SLSC, and 39 High Court Legal Service Committees. These many bodies exist across the country which provide legal help to people. Now, what kind of legal help are we talking about constantly here? Legal service. Number one, payment of court fees. If at any level you have to file a case, court fees is required, you can approach that level. If you're filing a case in the taluk, some lower court, go to TLSC. You're filing a case in district court, go to DALSA. You're filing a case in the sessions court, go to SALSA. You're filing a case in High Court, go to High Court Legal Service Committee. You're filing a case in Supreme Court, approach the Supreme Court Legal Service Committee. They'll provide you money for court fees. Then providing service of lawyers. They provide you service of lawyers also. If you cannot afford a lawyer, because Harish Salve is charging 30 lakh rupees per session per hearing, or Abhishek Manu Singhvi is charging 20, I don't know the fees. I'm just making a guess. If they are charging lakhs of rupees, we can't afford it. So what happens to us if we want to file a case? So they provide services of lawyers also, free of cost. Free of cost. Then once, let's say, a judgment has been passed in your favor, you want the copy of judgment from the court, you have to pay some money, say 200 rupees. A poor person, a daily wage earner may not be able to afford 200 rupees. You can get help and get certified legal copies from court. Money is paid by the respective legal service authority. Or preparing appeals, paper books, printing, translating judgments, translating documents, any kind of monetary expenditure, including getting a lawyer, that is required in filing a court case, every damn thing is provided for by the legal service authorities at various levels. This is the amount of help the governments are providing for us to access justice. And just to give you a figure, in 2021, the figure we have, For Salsas, 145 crore rupees were allocated by the government. 145 crore rupees. And almost 80% of the Indian public is a direct beneficiary of Salsa. How? So all these legal services are to be provided to which category of people? Anyone? Of course, not everyone. Some criteria is there. So all women and children, all SC/STs, transgenders whose annual income does not exceed 2 lakh rupees. This is in Delhi. Only in Delhi we have this kind of provision as of now. Then industrial workmen, all the victims of floods, droughts, disasters, earthquake, any kind of pandemic victims, disabled people, people in jail, people whose annual income is less than 1 lakh rupees, right? This is the eligibility for the availing the benefits of NALSA, SALSA, DALSA, TLSC, HLSC, etc. And victims of trafficking in human beings. So these are the people or categories of people who can approach these authorities and get benefit, legal help, plus monetary help pertaining to fighting court cases. That's it. It's limited to court cases only. So this is the eligibility criteria. So this is a very, an outstanding program. And just to point this out, the free legal service, especially for lawyers, you will be surprised that in high courts and district dalsas, we have roughly 50,000 lawyers who are providing their services free of cost to people across the country. So just an example, the panel of lawyers at High Court Legal Service Committee and DALSA, the district level and High Court level. More than 50,000 people are there, lawyers, advocates who are providing services to people. 50,168 is the number of lawyers. Beyond that, there are over 43,000 paralegal volunteers also. Maybe law college student, first year, second year, fourth year, fifth year students are providing legal awareness to the people. Roughly 1 lakh people are providing these kind of services across the country to these categories of people. Okay, that's it. So this is there with respect to the services being provided by NALSA, SALSA, DALSA, TLSC, Supreme Court Legal Service Committee, and High Court Legal Service Committee. Okay. Solve a question came in 2020. Great, 73% marked A as the right answer. In India, legal services authorities provide free legal service to which of the following types of citizens? Person with annual income of less than 1 lakh rupees. Absolutely correct. One is correct. This can't be the answer. This can't be the answer. 2 or 4. Look at 4. All senior citizens. Of course not. Rajnikant is a senior citizen. He does not need any free legal aid from anyone. Amitabh Bachchan is a senior citizen. In couple of years, Salman Khan, Shah Rukh will be senior citizens. That's not possible. So 4 is out. So A, 1 and 2 only. Of course, transgender with annual income of less than rupees 2 lakhs. Though this is only meant for Delhi. Now, I'll tell you what is the problem with this question. This question is not appropriately correct, because this annual income of 1 lakh rupees is actually an old figure, because lot of states have increased this limit. 1 lakh is too less. In Supreme Court, this is 5 lakh rupees. You have to have annual income of less than 5 lakh rupees to be a poor, right? 1 lakh is too less. If somebody is earning 2 lakh rupees, will you call him a rich person? So he has to find his own lawyer? Of course not. Then some states like Andhra Pradesh, Himachal, Assam, Haryana, Maharashtra, Tamil Nadu, they have increased this to 3 lakh rupees. Some states like Maharashtra, Andhra Pradesh, Haryana, this is 3 lakh rupees. Even in some other states like Bihar, Rajasthan, it's 1.5 lakh rupees. Then there are some states like Mizoram. In Mizoram, the limit is 25,000 rupees. The moment you earn more than 25,000 rupees per year, you cannot avail benefit under NALSA, SALSA, etc. That's hilarious. But anyway, but the sad part is this statement made by UPSC in one question. This statement is actually incorrect. But I think they simply borrowed this from Lakshmikant, because that's where it is mentioned. And whoever said this question, he or she simply copied the statement without even looking at NALSA website. That's a sad state of affairs for some of the UPSC's questions. So you know very well what is the quality of the amazing questions set up by UPSC. They may not always be factually correct, and sometimes if you know too much, that could be a problem also. Anyway, so this is there. But interestingly, think of this. In our country, we provide reservations, right, for in government jobs, for OBCs, for economically weaker sections based on economic criteria. For SC/ST, it's not economic, but for OBC and the open categories, we have reservation based on economic criteria also. There, if your family income is 8 lakhs or below 8 lakhs, you are a poor person, economically weaker section. So there, poverty level is 8 lakh rupees. Here, poverty level is 1 lakh rupees. Who is the real poor? I mean, are you considering that somebody who is getting 8 lakh rupees is poor, or is somebody who is getting 1 lakh rupees poor? Who is the real poor? So when it comes to government providing some service, they say, no, no, no. If you're earning 2 lakhs, you are a rich person. When it comes to giving some kind of freebie for vote bank politics, they say, no, no. 8 lakhs, poor person. What kind of criteria is this? If you're a poor here, you should be poor everywhere. If you are rich here, rich everywhere. What kind of selective criteria is this? If I have to give some service, my criteria changes. If I have to get some vote bank politics, I have to play some vote bank politics, my criteria changes. That is a sad state of affairs in politics in our country. Anyway, that's NALSA for you. Finally, before we discuss judicial independence, judicial issues, small topic, judicial independence. So you know very well that it is very, very important for the judiciary to be independent. I mean, it's of utmost importance for judiciary to be independent in the country, right? So for that, what do we have? So we have certain provisions. But before that, why do we need the judiciary to be independent? Need for judicial independence. Number one, the principle of separation of power, checks and balances between the legislature, executive, and judiciary. How can it be ensured if the judiciary is not independent? The balance between LEJ, it has to be ensured. Number one. Number two, in more than half of the cases in the country, executive, the government, is a party, is litigant. If the judiciary is not independent from the executive, how can judgments be independent? Because every case you see against government of India, against government of state, against government of India, of course. That's also a problem. So, independence of judiciary is very important. Otherwise, checks and balances can never be operationalized. Number three, rule of law. What is rule of law? More on this when we study fundamental rights, but just to clarify, as the phrase says itself, the phrase itself is very clear. Rule of law. Rule is not of people. People don't govern us. Laws govern us. And that is why we say when you clear the examination and you become a district magistrate, are you the DM? No, no, no. You are simply a person who is manning the very august and important institution of a district magistrate for a temporary period. That's who you are. That is why we say, every civil servant has to also play a very important role of being impartial, role of impartiality, neutrality. Why? Be impartial to everybody, be neutral, and also ensure that you are not too attached to the post, because people don't respect you, they respect the post. And that is something that you ask any retired civil servant, they'll tell you the day they retire, those phone calls, those sweet boxes, all come to an abrupt end on the day of retirement, because people don't respect you, they respect the institution you are manning. So basically, every person who is in the role of authority, they don't govern us, the rules govern us. That's why we say the law is the king of all the kings. Government or any kind of system which is based on the principles of laws, that is called rule of law. Rule of law refers to simple idea: no arbitrary powers to state. Meaning, state's power has to be limited. Limitation of power. If judiciary is not independent, then who will curb the executive? Otherwise, governments can go on and take away all our rights. If left for themselves, governments will simply take away all our rights. That's the big problem. So, we need an independent judiciary to keep a check on the government, to uphold the rule of laws, not of people. All manner of people have to be treated equally in the eyes of law. That is why we need an independent judiciary. Then, to protect democratic rights of people, of course. To tell you simply, see, in a democratic structure, as it is, popularly said, in democracy, it is the good orators who govern, right? Not the intelligent minds. But anyway, in a democracy, it is a majoritarian government. If you are in a majority, as a vote bank politics, you choose your own government. So government always responds to majority because that is their vote bank. So who takes care of the majority? For the majority, we have the government, because the parliament, the legislature, the executive are chosen by the majority. But who will protect the rights of minority? And by minority, I mean all kinds of minorities. The rights of minorities will be protected by the judiciary, because we already have the protector of majority of the people, government. Government, of course, will always respond to the majority only, vote bank. The minority will be protected by the judiciary. That is why the purpose of judiciary is to ensure that this democracy does not become the tyranny of majority. It does not become a play tool at the hands of majority. It's very important. And of course, to preserve federalism. Norms of federal polity, meaning division of power, protecting the powers of states. It can never be obtained if you don't have independent judiciary, because center always wants to interfere and control every kind of power. How and who will protect the states? So, to preserve federalism, meaning protect powers of the states, we need an independent judiciary for all these reasons. So, if any question is asked on independent judiciary, we know what to write. Then, how to ensure independence? So, in the constitution, you will find there are a lot of provisions which are there which ensure independence of Supreme Court and the High Courts. Appointment, now they have something called a collegium, which is too much of independence. Removal, very difficult process of removal. Article 124, 124 clause 4 and 5, very difficult. It requires what? A special majority to remove judges. Then, conduct of judges cannot be discussed in the legislature. If you try to discuss the conduct of any judge in the parliament or the state assembly, you can be also removed, you can be expelled. It amounts to violating the parliamentary privilege. A privilege motion can be moved against you if you try to discuss the behavior of a judge. You can't discuss such things in the parliament. This is Article 121. Then we know very well, if you have been a Supreme Court judge, you will not be allowed to practice in future. Simple. Their salaries, their allowances, charge expenditure, they are charged on the CFI, CFS, can't be reduced. They have the power to make their own rules. Article 145. Who makes the rules? Supreme Court makes rules with president's permission. That permission is nothing. It's just a ceremonial kind of permission, nominal permission. The real power is Supreme Court's power. They handle everything inside the court system. Court fees, who gets what kind of case, everything handled by Supreme Court, High Courts themselves. And lastly, contempt power. If you pass too many comments on the Supreme Court, negative comments, they don't like it, contempt punishment. You pass comments on High Court, they don't like it, contempt punishment. You can be jailed for up to 6 months under contempt of court case. That's there. These are provisions to ensure independence of judiciary. Okay. Solve a question, came in 2012. Oh, poll. I'll launch the poll after 10-15 seconds. I've only given 30 seconds time. Great, 68% got the correct answer. While appointing the Supreme Court judges, the President of India has to consult Chief Justice of India. So that is there. Okay, one is correct. Very good. One is correct. Remove this. Remove this. So 3 has to be correct. It's there in both. 3 has to be correct. Ignore 3. Let's check 2. The Supreme Court judges can be removed by the Chief Justice of India? Of course not. Supreme Court judges can be removed only by the Parliament. 2 is wrong. This is wrong. We have the answer. Just 2 statements and we have the answer. The salaries of judges are charged on the CFI of courts. All appointments of officers and staff of Supreme Court of India are made by government only after consulting Chief Justice. It is the opposite actually. All the appointment of officers and staff of Supreme Court are made by the Chief Justice in consultation with the President. So 4 is also wrong. A is the right answer. Okay. So that is all as far as our judicial independence is concerned. Now we'll discuss the issues concerning judiciary of course, let's take a break. After the break, we'll come back and take our case further on discussing some issues concerning judiciary, right with the very first issue that would be the pendency of cases. Break, please. Be back at 6.